Mr. Francisco, the removal clause comes from the the removal cases focus on the vesting clause in Article 2. So there is a textual hook.
Well, and here, Your Honor, there is a textual hook as well in the appropriations clause, which again is set forth in Section 9 of Article 1, which actually sets forth limitations and obligations upon Congress.
Except the limit's not there. I mean, I guess that's what I'm struggling with, and I take it some of the other questions are too. I mean, you have the unitary executive theory, right? And you would say, well, if all executive power has to be in the president, then his ability to fire someone, his ability to remove someone can't be hindered. But here, you were just saying to Justice Jackson that there's nothing in the appropriations clause itself or in the word appropriations that imposes the limits that you're talking about.
No, what I'm saying is that the word appropriation is, you can interpret it in different ways. At its core, what the appropriations clause does, Congress has to make an appropriation. It's got to determine what the government should be spending. It's got to determine the amount that it should be spending. And it's got a non-delegation component baked into it because you cannot simply transfer that core legislative function to the executive branch. And that's why I think that even if you put the issue of a cap aside, even if you think that this is a meaningful band of discretion, it's an extraordinarily wide band of discretion that excuses—
What if you said, like, 4 years, $400 million a year? Would that be a problem?
If it were $400 million a year, I think that would be fine. If it said
so
to the
$600 million was
if it said to the well, what I'm getting at is if Congress is fixing the right amount, the amount should be $400 million or the amount should be $600 million. That would be a much more difficult case for me. But when Congress is doing what it did here, it's saying to the director, you pick the amount that you think is reasonably necessary. It could be zero. It could be $750 million. It's taking that core element of an appropriation, determining the amount that the government should be spending, and it's saying, we, Congress, are not going to exercise that judgment. We're kicking that over to you, the executive branch, to exercise that judgment. And that is what's so problematic and is what is so also historically unprecedented if we're going to use precedent as the test. The only counterexamples tend to be these self-funding agencies, the Post Office, the Patent Office. They're modern-day analogs. Well, they don't get to pick their amount because they're different in a meaningful sense. They're limited to what they can collect from the people they regulate and serve. And there's a historical tradition for those types of agencies. But that history tells us a couple of other things, too. It's never been extended beyond that group of agencies. That model was rejected for the CFPB. That was actually the model that President Obama proposed for the CFPB. But Congress rejected it because it wanted to make this agency even more independent. And finally, if you do think that's the model, there really is no limit, because those agencies don't even have a cap. So Congress could just say to every agency, spend whatever you think reasonably appropriate. You make the frontline judgment within this very broad range of discretion in something maybe not quite perpetual but close to it.
Thank you.